So I think the big issue for Missouri lawyers right now regarding a recently enacted rules change by the Missouri Supreme Court to Rule 4-1.22, which addresses the lawyer's ethical obligation to maintain the client file. In Missouri, of course, the client file is the client file. It does not belong to the attorney. It's actually the property. The original file is actually the property of the client, and the client file consists of the file from cover to cover. In Missouri, there's a very expansive view of the material in the file that belongs to the client. So that includes not just the paper that's produced as part of the representation, but as well as all of the material produced as part of the representation, which could include such things as emails, obviously in communications with the client or adverse counsel, an expert witness, whomever. If a lawyer is communicating with a client by text message, for example, those texts are part of the file. So a lawyer would have to develop a procedure for maintaining those texts, archiving them so they could be reproduced in the future. Probably the most significant aspect of the rule change is that it reduces the number of years from 10 years to 6 years from the conclusion or termination of the representation that a lawyer would be required ethically to maintain the client file. After the new 6-year period or the old 10-year period, the file is deemed abandoned by the client. So the lawyer would then be permitted ethically to destroy the file ethically without further communication or permission from the client. Any destruction of the file that occurs before that or within that time frame, that either the 10-year or the 6-year time frame, can only be done with the client's informed consent. So there may be some additional hoops that a lawyer would have to jump through in order to reduce that time frame from the 6 years as required by the new rule, as opposed to some lesser time frame that a lawyer would want to implement as part of their file retention procedure inside the firm. If a lawyer has questions regarding their duties to maintain client files under the old rule or the new rule, the first thing I would recommend, obviously, is to look at the appropriate rule. Have the lawyer read the rule and make sure they understand the application and implementation of the rule itself. If there are any questions after that, I would encourage them to call the Bar Plans Risk Management Department, and they can talk to me or they can talk to Whitney, and we can, depending on how many moving parts there are in their situation at their firm for file retention, we can walk them through and hopefully get them to a place in their file retention procedures that work for them.